Hey everybody, Steve Schwinn here, University of Illinois Chicago Law School. So there's been a lot of talk recently about President Trump's nomination of Judge Amy Coney Barrett to the United States Supreme Court and what that could mean for the future of the Affordable Care Act. Remember, the Supreme Court's going to hear oral arguments in the latest round of litigation challenging the Affordable Care Act on November 10th. If Judge Amy Coney Barrett is confirmed by the Senate, she could take her seat on the court for that oral argument and be a part of the court in determining the constitutionality of the Affordable Care Act as it's currently configured. So let's take a look at that. Remember, a central piece of the Affordable Care Act is the so-called individual mandate. This is the way that it works. We, as individuals, have a choice. We can purchase health insurance, or we can pay a tax penalty. The Supreme Court in the NFIB versus Sebelius case, the first case challenging Obamacare, upheld the individual mandate under Congress's authority to tax, under Congress's taxation authority. What the court said was because the tax penalty could generate revenue for the government, that's an exercise of Congress's taxing power. And so when Congress gives somebody a choice to pay a tax penalty or do something else, whatever it is, in this case get insurance, that's an exercise of the Congress's taxing authority. But more recently, the Republican Congress set the tax penalty at 0, which means that the federal government is no longer earning revenue from tax penalty payers if they decline to get individual insurance, which means, according to the argument in the case going to the Supreme Court, that the individual mandate is no longer supported by Congress's power to tax. And if it's not supported by Congress's power to tax, there's no other authority that Congress has to enact the individual mandate, and the individual mandate as constructed must be unconstitutional. Now, there's more to the case. There's more to the case that's going to the Supreme Court, and that's because, remember, the individual mandate doesn't operate alone. Right? When Congress put the Affordable Care Act package together, it created a kind of three-legged stool. So the individual mandate operated with a couple of other provisions. One of those provisions was called guaranteed issue. Guaranteed issue meant that insurers could not discriminate against individuals with pre-existing conditions. Insurers could not deny coverage for individuals with pre-existing conditions under the Affordable Care Act. The other provision, remember I said there were three, 1, 2, the other one was community rating. Community rating means that insurance rates have to be between a particular band, that insurance companies can't charge outsized rates for individuals based on their health conditions or their pre-existing conditions, or much lower rates for individuals because they don't have those pre-existing conditions. Now, between the two, guaranteed issue and community rating, right, it's a three-legged stool, so let's draw it this way. Between guaranteed issue and community rating, if those requirements operated on insurance companies alone, we would expect rates to go through the roof. That's because insurance companies would have to take on individuals with pre-existing conditions and could not adjust rates based on pre-existing conditions. What are they going to do? Drive rates through the roof. The way to keep them down, or at least part of the way to keep them down, was to get everybody into the insurance pool, including healthy individuals. If more people are in the insurance pool, more healthy people are in the insurance pool, that's going to keep rates at a lower rate. And that, along with some other features of the Affordable Care Act, would keep rates affordable. And so the way Congress designed the Affordable Care Act in the first place was based on this three-legged stool that between the individual mandate, guaranteed issue, community rating, we could get universal coverage, make sure that people get into the pool, and that they're not discriminated against because of pre-existing conditions. Now, there were other provisions in Obamacare as well, right? Creation of the marketplaces for buying individual insurance, requirements of different kinds of insurance products that insurance companies were putting on the market. And remember this one, that young people could stay on the health insurance of their parents until they were age 26, right? All those things were tied up in this package as well. And so the current challenge to the Affordable Care Act says the individual mandate is unconstitutional, but because all these other provisions are bundled up with the individual mandate, they too must fail. And that's the position that the Trump administration has taken, and the opponents of the Affordable Care Act have taken in the litigation that's due to go to the Supreme Court. Now, this question raises an issue of what we call severability. The question is this: if the individual mandate is severable from the rest of the Act, in other words, if you can pull it apart from the other provisions in the Act and say the individual mandate is unconstitutional, but the other portions of the Act can stay on the books, then the court might rule that the individual mandate is unconstitutional, but leave these other provisions on the books. If, on the other hand, the individual mandate is so wound up with these other provisions that it's not severable, you simply can't pull it apart, you can't take it out of the rest of the provisions of the Affordable Care Act, well, then the court will say that it's not severable. And if the court rules that the individual mandate is unconstitutional, then the rest of the Act must fall as well. Not just the other two legs of the three-legged stool, but also the other provisions potentially in the Affordable Care Act, the other ones that we mentioned a second ago, everything from the marketplaces to the age 26 stay on your parents' health insurance provision in the Affordable Care Act. Now, that brings us to this case, right? So what happened in the NFIB case is you had Chief Justice Roberts, plus the four progressives on the court saying that the individual mandate, as it was then constructed, was constitutional under Congress's taxing authority. Okay? Now, here's the thing. Given that Congress has changed the tax penalty to zero, it's not at all clear how many of the justices in this coalition would still go along and say that Congress has power under its taxing authority to implement the individual mandate. That's because Chief Justice Roberts, in his opinion that said the individual mandate was justified and valid under Congress's taxing authority, Chief Justice Roberts said the touchstone for a tax is that it raises revenue for the government. Well, this doesn't. And so that could be problematic for the chief and maybe for some of the other progressives. Now, the other thing that's happened is that we have unfortunately lost one of the progressives, right? Ruth Bader Ginsburg, Justice Ruth Bader Ginsburg, died the other week and left the court. And so if President Trump replaces her with Judge Amy Coney Barrett, that could impact the lineup on whether the individual mandate is unconstitutional. Well, here's the thing. Judge Amy Coney Barrett is already on record criticizing the court for its ruling in the NFIB versus Sebelius case that Congress had authority to implement the individual mandate pursuant to its taxing authority. Now, I would think even all the more so, given that the tax penalty is now zero. So, if we replace one of the progressives here with somebody who is highly critical of the individual mandate, even as it was constructed in NFIB versus Sebelius, but even more so now that the tax penalty is zero, well, then we change the lineup altogether, right? Then the lineup becomes Chief Justice Roberts and 3 progressives, and 1 plus 3 only equals 4. Then you have 5 people on the other side of the equation. And moreover, again, we don't know how the chief's going to rule in the case on November 10th because there's a significant difference between this case and the earlier case. Again, the tax penalty is 0. In truth, we don't know how the other progressives would rule either, because we didn't have this situation in the earlier case. So the court looks like it very well could rule the newly constructed with a tax penalty 0, this newly constructed individual mandate, could rule it unconstitutional. But then the next question is the severability question. If the tax penalty is unconstitutional, the individual mandate is unconstitutional, how much of the rest of the act is unconstitutional? Well, there's a good bet that you've got at least a couple on the court that will say a good portion of the rest of the Affordable Care Act is unconstitutional. Do you have a majority? We just don't know. We just don't know. Now, even if the court were to say that the individual mandate as currently constructed is unconstitutional, and even if the court said that it is not severable and so other provisions of the Affordable Care Act must fail as well, even if Congress can actually undo some of that if there's congressional will. So, for example, Congress could reimpose a tax penalty. We already have it on the books that a tax penalty is valid under Congress's taxing authority. So unless the court, with now Justice Amy Coney Barrett, would change course from NFIB versus Sebelius, a case decided just a handful of years ago, we know that a tax penalty with an actual number here is justified under Congress's Commerce Clause authority. And at that point, we're not even asking the constitutional question about the rest of the act, because if the individual mandate is upheld, we don't worry about severability. So Justice Amy Coney Barrett could make a significant difference in this case, depending on how she and the Chief and the other progressives would rule on the individual mandate with the tax penalty set at 0, and how they would rule on severability. But that said, Congress could actually undo much of what the court might do in this case by resetting a tax penalty at some number greater than 0, so that the federal government would actually earn revenue from the tax penalty. If so, then the individual mandate would be upheld under NFIB versus Sebelius, and we don't even come to the question of severability. I hope this was helpful, and I'll look forward to seeing you again. Take care.